All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Marilyn Brennan is now session. Please be seated.
Good morning. How's everybody doing? Good? It's our first arguments for March. We're gonna have a rainy week. We'll see what the river looks like at the end of the week. Hope it won't look like it did last year. All righty, so we have a fairly large docket and 4 cases, really 5 to a consolidated, are going to be arguing this morning. So I'll be calling the entire docket, including the cases that have submitted on the briefs. Pardon me. The first case is C, and then if attorneys can please identify themselves and their readiness to proceed. The first case is C250213, which is Urban Investors Mount Lookout LLC versus Scott Williams.
Steve Davis on behalf of the appellants for Urban Investors.
Good morning.
Dave Everly, here with Scott Williams, the FLE, and we're ready to proceed.
Good morning. All righty, then we have C250415, Absolute Resolutions Investments LLC versus Justin C. Marshall.
Morning, Your Honor. Andrew Barnes for the appellant and Justin Marshall. Ready to proceed.
Good morning.
Morning, Your Honors. David Hoff for the appellate. And Boyd Gentry also.
Okay, good morning. Next case we have is case number C250309, Stephen J. Kuiper versus Carrie E. Kuiper.
Good morning, Your Honor. Jay Clark for the appellant, Carrie Kuiper.
Good morning.
Blake Summers for the appellee, Steve Kuiper, ready to proceed.
Good morning. The next case we have has submitted on the briefs. It is case number C250246-261, which is Stephen Stryker versus Mary Jane Stryker. The following case is also submitted on the brief, C250353, State of Ohio versus Thurman Malley. The next case is scheduled to argue, and these are consolidated. They are cases C250095, Richard, and I'm sure I'm going to say this wrong, Buriran versus Durrani et al., C250206, Kyra McLinden versus Durrani et al.
Good morning, Your Honor. Aaron Herzig and Philip Williamson for appellants ready to proceed.
Are you going to be splitting time?
No.
Okay, all right.
Alan Staffman and Ben Moran on behalf of the applicants. The name is Brorin.
Thank you. So say that again? Brorin. Okay, like a bro, except it continues to be a rin. Got it. All right. All right, thank you so much. Thank you for clarifying that. All right, so we're going to start it with Urban Investors, Mount Lookout, Scott Williams. Good morning, Attorney Davis.
Good morning.
You can come forward when you're ready. Would you like to reserve time?
I would like to reserve 3 minutes.
Okay. Whenever you're ready.
Thank you. May it please the court. Counsel, again, my name is Steve Davis. I represent 3 parties today, the appellants, Urban Investors Mount Lookout LLC, 3544 Linwood LLC, and a gentleman named John Wallace. We are here today seeking reversal of the trial court's decision through Judge Roman awarding Mr. Williams what amounts to back pay during a period of time in which he was, we contend, under default under a lease option agreement that was executed back prior to 2019 with one of my clients, John Wallace. There are 3 issues that I'll be discussing today. I'll briefly discuss each and then go into them in slightly more detail. The first concerns what I'll call an interplay between the idea of how a court speaks through its docket, and yet at the same time we can understand that a court's order contains certain implied findings or implied rulings. The second issue I've characterized in my brief as an issue of collateral estoppel, and I'm happy to get to that because in reviewing for today's presentation, it occurs to me that I didn't brief that particularly well. There's a significant issue in that case that I left out of my brief that I'll get to.
Well, should you get to it if you left it out in your brief, though?
I'm sorry?
Should you get to it if you left it out in your brief?
Well, no, it's, let me present it, and it's not as though, it's not a waived argument. It has to do with collateral estoppel, but it has to do, and I'll address it briefly now. I make a lot of discussion in my brief about that Judge Heekin's order was final, if not appealable, and whether or not it was a final appealable order, it was certainly final for purposes of collateral estoppel. I think what I may have overlooked is when the 2019 case was dismissed by stipulation, it became final. So, I mean, final and appealable at that point, and was not appealed.
And
So-
that dismissal, because the entry discusses the dismissal as a dismissal of the case. So it seems to me that it's a dismissal under Civil Rule 41A1B. Is that what you,
By
is that?
stipulation, yes.
Okay.
And I think to the extent that the argument has been made that Judge Heekin's order was interlocutory and subject to revision at any time, the argument that I made in my brief was, well, at least the finality part of it is enough to imply collateral estoppel. Again, I think I overlooked the fact that whether or not we're talking about final and appealable, it was both upon the stipulation.
Well, can you explain that? First of all, I'm interested in hearing why you believe it was final appealable, and then the distinction you're making.
Well, when Judge Heekin ordered specific performance, there were 2 counts in the complaint. There was a complaint for damages, there was a complaint for specific performance. Judge Heekin's order did not address damages, so it didn't resolve all the claims of all the parties, and Judge Heekin's order didn't contain the no just cause for delay language that would have made it final and appealable.
Right, because there were counterclaims pending as well, right?
And there was a counterclaim pending as well.
Okay. So it was not a final appealable order.
It was, I would contend it wasn't an appealable order, but it was a final order,
Right, well, that's the distinction.
Correct,
So
that's
it
the
was not a
distinction.
final appealable order,
but it was a final order,
okay.
I contend,
And why was it a final order?
because it affected a substantial right. Inasmuch as the order ordered Mr. Williams to divest himself of his property, and that in fact occurred, that order was a final order. And I
There
think
was still a
that's
counterclaim, is that correct?
correct.
Okay.
There
and
was at the time.
And so can you explain from your perspective why it's a final order regardless of the counterclaim that was still pending?
Because it resolved the issue of ownership of Mr. Williams' property. The only thing that was left was damages. So when Judge Heekin ruled for specific performance and the property closed, that resolved the equitable aspects of the claim, leaving only open the damages aspects of the claim, of which I had a damages claim and they had a damages claim. But by completely resolving the equitable issue and ordering the divestiture of the property and the fact that that occurred, I believe make that a final order.
Is that the key, though? It's the fact that it actually occurred, the specific performance
Well-
occurred and a closing occurred.
That was certainly how I briefed it.
Yeah.
The fact that the closing occurred made that a final order.
So with regard to res judicata and the case law on that, it's not that we need a final appealable order, we need a final order.
Correct.
And there's a distinction there.
That's correct.
Okay.
But again, I would go a step further because I think it became a final appealable order upon the stipulation of dismissal. Okay?
Okay.
Let me backtrack back to my first issue. Judge Heekin ordered Williams to go to closing and sell his property. That order could not have occurred if there had not been a finding that Mr. Williams was in breach. The alternative is bizarre in my mind. The alternative is to tell Mr. Williams, you didn't breach the agreement, but we're going to make you sell your property anyway. And I don't think that's a tenable outcome of that.
And it sounds like Judge Ruhlman disagreed with that
Yeah, he did.
finding.
Certainly
He thought
did.
there was a breach.
Certainly,
Yeah.
yeah. But our contention is, he didn't have the right to do
He
that.
couldn't do anything about it, is what you're saying.
Right.
Because it wasn't interlocutory.
Judge Ruhlman considered the argument of Williams that Judge Heekin's order didn't use the word breach and therefore didn't resolve it. And therefore, he felt empowered to be able to do that 6 years after Judge Heekin issued the order of specific performance. And my contention is, it doesn't matter whether Judge Heekin actually used the word breach. He ordered Mr. Williams to sell his property. How else could he have reached that conclusion? And so
I need for you to explain one thing to me. I'm a little confused about how you, in your brief, have conceded that your client owes the taxes from
2018 through 2020.
Thank you. And including the time where you're claiming under contract, it should have been owned by your client, correct?
I think the evidence that was adduced in front of Judge Ruhlman showed that, yes.
Okay. But if you are correct and Judge Heekin found a breach and ordered specific performance because of it, your argument is that he or your client should have owned that property starting in, was it August, September?
Yeah.
Yeah,
the summer-
sometime in there.
Summer
So-
of 2019.
Yes. So your argument is that because your client should have owned the property starting at that point, that your client doesn't owe any rent.
Back rent, correct.
So why would your client owe the back rent but not the taxes?
Well, we contend that they didn't owe the back rent. The only reason that I conceded the issue of taxes is because, and again, Mr. Williams paid some taxes during a period of time that we felt like we were the owner of the property. That wasn't his obligation. And by paying those taxes, I didn't object to reimbursing him for that. I think it's an actually entirely consistent position. I shouldn't have had to pay you back taxes because I owned the property. Excuse me, back rent because I should have owned the property. You paid the taxes when I should have owned the property. And you produced a receipt showing that you paid these taxes. I think it's fair and reasonable to pay you back for that. So I
Okay.
didn't contest that.
Thank you.
Part of this is an issue of fairness, and you've touched on that now. To the extent that Judge Heekin ruled that Mr. Williams should have gone to closing but didn't in the summer of 2019, and instead what I'll consider to be held over until he was actually forced to close 9 months later, for Mr. Williams to suggest that he's entitled to rent during that period, which is my third issue, I think strikes at a matter of fundamental unfairness, and that's quite simply how I've characterized it. I think not only didn't he have a legal right to this back pay, I don't think he has an equitable right to the back rent either. To suggest that he has the right to, as Judge Heekin ruled, you should have closed in the summer, but he stays, and while he stays says, you know what, I should have closed, but now I want rent. And I don't know that there's that much more that needs to be said with respect to the third issue. I'm trying to think if I've adequately.
What do you
Thank
make of Judge Ruhlman's discussion about the entries by Judge Heekin contradicting each other?
Thank you. I knew there was one more thing I wanted to discuss, the motion to dismiss.
Yeah.
Judge Ruhlman, one of the reasons why he felt he was justified to revisit the issue of breach is that after the court granted specific performance, I moved to dismiss the counterclaim, and it was denied. I don't think they're inconsistent at all. I mean, a motion to dismiss and a motion for summary judgment are two very different things. in their counterclaim, they alleged that that we did not properly exercise the option to purchase. That ended that whole analysis.
Right.
They alleged it.
Because you don't look outside the pleadings.
You don't look outside the pleadings. So although Judge Heekin didn't articulate it, he did say, upon review of the facts and the law, which I interpret to mean the law that says you don't look outside the pleadings, and the pleadings say that we didn't properly give notice, even though he had earlier ruled that they had. He denied the motion to dismiss. For Judge Ruhlman to say, I find those things to be inconsistent, again, I found troubling and puzzling. You know, on the one hand, we've got a motion to dismiss where we're only supposed to look at the pleadings and not the facts, and then we have a prior decision on a motion for partial summary judgment where we're supposed to look only at the facts and not at the pleadings. To suggest those two things are inconsistent, again, I think is an incorrect decision. With 25 seconds to go, I'll simply repeat my request. We would ask that this court reverse that portion of the trial court's judgment awarding back grant to Mr. Williams. Thank you.
Thank you.
Morning, everyone.
Good morning.
Thank you to the court. May it please the court and counsel. Thank you for your time and efforts on your role today. I want to address something that Mr. Davis didn't address at all, but was inconsistent in our briefs, which is the standard of review here briefly. He has alleged in his briefs that the standard of review should be de novo. I don't think it should be. I think it should be the standard of review afforded a trial court that's gone through a trial, as we have here.
Well, aren't we, I mean, isn't the main issue in this case the res judicata issue?
I mean, that's how they've framed it.
I mean,
from
but
our-
isn't that everything in this case? Because if the prior order stands,
Except that Judge Ruhlman, and we'll use those names to kind of distinguish between the three orders that are critical here, I think. Judge Ruhlman specifically found, and this is the order that he's appealing, that the entry, the February 2020 entry, which is what you're talking about, the order to close, right, entry, was not an implicit finding. That's the law part, right? But that the ruling itself was supported and necessary for a trial because of the evidence that it heard at trial, that Judge Ruhlman actually heard from the parties. So I think it's both. I think it's a mixed combination, but he's clearly appealing a trial court's decision where evidence was adduced about breach at trial.
well, we have to interpret, first of all, what Judge Heekin meant by the first entry, right?
I
And
think
he ordered specific performance.
he did.
And so, doesn't that mean that he found the breach?
It doesn't say.
I know it
And-
doesn't say, but how else could he award specific performance if he didn't make that?
He's sitting in
Finding.
equity, and I honestly think what he did, and maybe this isn't legally precise, I think he saw two parties that had a contract, there was a dispute about whether it was breached, and he said, Scott, sell that house to them at the price you demanded, and we'll see what comes of it.
But under what authority would he be able to do that unless he found a breach?
I'm not saying it was the right decision. I don't think it was the right decision, frankly. But I think the key, if we're going to try to divine his head about what he was thinking, I think the best window into it is his subsequent decision on the party's motion to dismiss the counterclaim of my client. That motion to dismiss, and I understand it's a motion to dismiss, not a motion for summary judgment.
Isn't that a huge difference? I mean, he's only looking at the pleadings in a motion to dismiss.
I don't think so here. And the reason I say that is because this motion to dismiss decision took place in time after the closing took place and after he ordered closing. And so are these positions inconsistent? I think they could be. But his subsequent finding was that the motion to dismiss should be denied. And the court, sure, it's supposed to look at the four pleadings for a motion to dismiss, no doubt. But what did the court already know? It already had briefed and ruled on a partial motion for a summary judgment. It knew its own order, and certainly could take judicial notice of its previous finding. It could have converted the motion to dismiss into a motion for summary judgment under the rules.
But it also could deny it based on,
We don't know why
Looking
he
at the
denied it,
pleadings.
but we don't know why he denied it. And so when you've got two decisions, the second one of which is later in time, one might think of the opportunity a trial court has to reverse itself, frankly, here.
I'd like for you
motions
to
to
help me
reconsider could be
understand
considered.
something.
Yeah, I'm
Okay.
sorry.
The dismissal by stipulation of the parties, okay? What is the legal effect of that?
I don't think it had any legal effect for purposes of res judicata or collateral estoppel. I think the appellant's argument is that the order to close was a final order, and I appreciate the court's analysis of final versus final and appealable.
Do you agree that for res judicata purposes, you don't need a final appealable order, you need a final order?
I think that's correct, but I think the motion to dismiss decision was also a final order, which was not appealed from. If that was an improper decision, because it was a motion to dismiss the counterclaim.
But this is what I'm trying to understand. If there is a dismissal of the case, by stipulation of the parties, that means the case no longer exists, right?
Right.
So, do you see what I'm saying?
Can you
I'm
have a
trying
res
to under-
judicata on a subsequently filed case?
I'm trying to understand, like, what's the legal effect of that?
Right.
When you have a motion for summary judgment that doesn't have the 54 language on it, right?
Right.
So I understand that there was a sale, and, this is like very convoluted,
The procedural history is
right?
bananas,
It's
no doubt.
very bananas,
Right.
yes?
Right.
But there was a dismissal of the case
Right,
by the stipulation of the parties, right?
right.
And so I don't know how that even brings, I'm trying to understand if and that really does bring,
I don't think it does, but if there is one
Finality
thing that was.
because it's a dismissal of the case.
Right,
Is it without prejudice? the
was
decision?
without prejudice, and we refiled.
And this was a refiling?
Right,
Yeah.
right.
So
Now,
that allows it to be refiled, but we still have to look at what's the effect. So, again, what's the legal effect of a dismissal pursuant to Civil Rule 41A1B, where both parties have agreed to dismiss the entirety of the case?
right, and to add to that, maybe I'm not helping the court's understanding, but to add to that, there's the notion that, I lost my train of thought, that the fact that the court issued two rulings that could have touched upon whether there was a breach of contract, decision made one way or the other, and then with the case being dismissed, I understand why Judge Ruhlman looked at the previous case and what was before him, concluded the court didn't really issue a final ruling insofar as having collateral estoppel or res judicata hinder his ability to make a decision as to Mr. Williams' counterclaim. Because the court did not say, I find that Scott Williams breached and therefore close.
Let me
It
ask the
just-
question, I'm going to ask the question completely differently. Let's pretend you don't know anything about this case.
Not too
I'm
far from
I'm
there,
not
Judge.
asking this question about this case at all. I'm just in a civil procedure class at
Right.
UC Law,
Right.
okay? What's the legal effect of a Civil Rule 41A1B dismissal?
There's
That's
no-
the question.
Yeah, there is no case left, right? And once refiled, the court looked at everything afresh and anew, looked at what had happened, decided that it was a different judge, it was a different human being, clearly, saw both orders, said, let's have a trial, heard the evidence, it was one-sided, no one's disputing that, that's not why they're here, and said, okay, I think that there was a breach and Mr. Williams is entitled to damages.
Are you saying that because the case was voluntarily dismissed and refiled, there cannot be a collateral estoppel effect to the prior?
I think that if there were a collateral estoppel effect, the only thing it would prevent us from doing is undoing the closing. Because that
Because
is.
it already happened.
Because it already happened, right?
But as far as, because it was voluntarily dismissed, the judge could then, let's say Judge Heekin did explicitly say there was a breach.
Right.
And the closing happened and then it was dismissed. Are you saying that Judge Ruhlman then could say there wasn't a breach?
I think he might not be able to if he had granted the motion to dismiss based on his own reasoning, but he didn't. When he got that motion to dismiss, he could have said, he's exactly right. I implicitly ruled there was a breach here, or I wouldn't have ordered closing. Therefore, since both parties can't breach the same contract, his counterclaim loses. But he expressly didn't say that. He said, no, that counterclaim survives. Then we dismissed the case and we relitigated.
Why was the case voluntarily dismissed?
It was about settlement and timing.
Oh, okay.
And so you touched upon the central issue, I think, with Mr. Davis, which is the case wasn't over once closing happened. And we know that because Judge Heekin himself said it's not over when he denied the motion to dismiss, knowing that closing has happened already. If he had reached the same conclusion that Mr. Davis is urging this court to do now, then Judge Heekin would have been a no-brainer. I'm dismissing the counterclaim. I've already ruled there's been a breach by him, thus forcing closing, thus he can't have a counterclaim. He expressly didn't say that. And when it was a refinal, that issue, not the closing, not whether closing was right, but whether there was a breach of the contract such that damages should flow to him and be paid to him, the judge said, no, we need to listen to that issue. We need to listen to that over again. Let's have a trial, and we won that trial. And so the first question I think you asked Mr. Davis was, the court didn't close the whole case with that closing order, did it? And the answer is clearly no, he didn't, on purpose. And when he had an opportunity to do so again, he said no again to do it. So the issue, the only issue before the court, then at trial, in the second case, and now before this court today was there a breach of the contract? And by them, such that he's entitled to damages. And that court said absolutely. I think this court should too, for the same reasons. The trial court did not adjudicate the entire case when it issued and ordered the parties to close.
So are you suggesting that we review this under a manifest weight?
I am, because the evidence adduced about that breach was clearly adduced at trial. It was not opposed by any way. The only really thing that was opposed at trial was the exact argument they're making here. They objected to the trial sort of taking place.
But is that being even challenged on appeal? I thought the only thing being challenged on appeal is the res judicata effect of the prior entry. I mean,
Yeah, except that the judge's entry relied upon the evidence at trial for clarification for this ruling.
right.
It's hard to square those two. I understand that you're thinking of a particularly
I just
legal
don't feel
issue.
like they've challenged anything else, any other aspect about the judge's ruling, except to say that the judge couldn't have so ruled because there was already a prior ruling.
Right, except it's sort of akin to saying I should have won my motion for summary judgment even though we had a trial and I lost. I mean, the facts adduced at trial demonstrate that prior ruling either wasn't res judicata. Part of it is that it was about whether the prior ruling was res judicata. What did Judge Heekin mean from that first ruling? And then that second ruling that seemed inconsistent. Let's have a trial and get to that.
But what's
actual
our
fact.
standard on that? Don't we have to figure out what a judge he can mean and whether it's res judicata?
I don't think we have to figure out what Judge Heekin meant, other than what he said in his ruling. I don't have to say, I agree that there's a breach or not a breach. He
Well, I
didn't say
don't
that.
think that he could, like I said, I don't think he could have granted specific performance without having found a breach. It just doesn't, it doesn't make any sense otherwise.
I think he could have an error, which we chose not to appeal. I think I think that was an
He could have
erroneous
granted
rule.
specific performance without finding a breach.
Erroneously, yes, yes. But if that were the case, if he found a breach then the motion to dismiss is easily and rightfully granted. And he didn't do that.
Not if he does it on the technical basis of that, only he can look at the pleadings.
But there are two challenges to that. One, he could have converted it to a motion for summary judgment, since he already heard those facts and ruled that
Did
way.
he have to, though?
I think so, because the second issue is that he also knows the law of his own case, right? He also knows that ruling that he's reached previously, and knows that's no longer, he could rely upon his own ruling and point to that to grant the motion to dismiss. That's not outside the floor, what his purview is. It's
Right.
clear to me, he just ordered closing and then said, wait a second, no, there is a counterclaim here, it should survive. We dismissed it, we tried that counterclaim, we won it. And so, to me, they are maybe a little inconsistent, but justice would not be served if the first prior ruling somehow, and I hate using this verb these days, trumped the rest of the stuff. Because it would be an injustice, frankly, in my view. Because as the court asked Mr. Davis right away at the beginning, wait, the case wasn't resolved when he ordered closing, was it? And the answer is definitely not. He had an opportunity to resolve the whole thing in that subsequent motion. Said, nope, that's not what I meant, is how I read that second ruling. I didn't mean that the case is over. I just thought you two yahoos should sell this building at the price you agreed to and move on. I really think that's what happened. Okay, well, the legal import of that is that we're here today 6 years later, right? And so,
You see, and all of that brings me back to the dismissal.
and once that case is
Because-
dismissed, if we had a chance. to do
And it's
one
interesting
thing-
because it was by stipulation of the parties.
Right.
So, the parties made this determination, and it might have been illogical because the property was sold, but this was something that the parties chose to do.
And we didn't appeal the closing, house is gone, but pay us the rent. And so I think both judges left that part open. Judge Ruhlman could have granted dispositive motion before trial on this issue and didn't. And so, to me, the clear intent was to have you guys close, but let's see what comes of that from a damages standpoint. He was sitting in equity when he closed. He was sitting in law with the damages. And I think we made the legal argument on the damages case. Your question about the taxes baffled me too, frankly, which is, if the res judicata argument should win the day, theoretically, no taxes should have been paid either, yet they conceded that, which I think is a little inconsistent. My time is up, I believe. So, thank you, Your Honor.
Thank
Any
you.
further questions before I get out of here? Thank you.
Attorney Davis, it's really interesting that, the parties fulfilled the order and sold the property, right?
Yes.
Okay. So does that change how does that change, if anything, how the stipulation of the dismissal of the stipulation of the parties, what legal effect that has?
I'm chomping at the bit to answer your question.
Okay.
I was fidgeting there. For Mr.
Because you were
Everly to say
thinking
there's
about it
no
while you were
law-
sitting there.
Pardon me?
Because you were thinking about it while you were sitting
Yeah,
there.
Well, for Mr. Everly to say there's no law on this, that's just wrong. There's a ton of law on this. The reason why the Judge Heacon's order was not appealable is because it didn't resolve all of the claims and all of the parties. When the case was dismissed by stipulation, that act resolved all of the claims of all of the parties.
Even though it was without prejudice?
Yes.
Can you explain that?
I don't know that I can explain it any more than to say that that's what the case law says. When you
Okay, can you
dismiss a
tell me-
case, it's as if it was never filed. It resolved my damages claim because I dismissed it. It resolved his damages claim because he dismissed it. Now all the claims are resolved.
But if it's without prejudice, does that not change whether
No,
it's
it
appealable?
becomes a final appealable order at that point. Suppose I had never refiled it. He has 30 days or whatever it is to file his notice of appeal.
There's a lot of case law saying that when a case is dismissed without prejudice, it is not appealable at that point. So do you have any particular case saying that it is?
Well, let me approach it a different way. I don't have a case right now that says that. My understanding is that's the law. But let's suppose it didn't. He has now tried his case to a judgment. Is it not now appealable?
Of course it is, because there's
Okay.
a judgment, a final judgment, and it's not a voluntary dismissal without prejudice, so no one can bring the case back.
Maybe what I need to do is loop back to the position I took all along, which is it doesn't matter whether it's appealable. What matters is that it's final. And the
Yeah,
finality.
but the problem is, going back to what Judge Zayas is questioning, when you dismiss a case
Mm-hmm.
and it's dismissed without prejudice, isn't it as if that case had never been filed? That's what you just said.
Yes.
So how do you get res judicata or collateral effect from a prior order in that case if we basically wipe that out as if it had never been filed?
Well, and maybe this is why I didn't brief it this way. That's probably the right analysis as I think about it. I think what ultimately this is going to turn on is that I had a final order, not a final appealable order, and perhaps because it was dismissed without prejudice, that wouldn't make it necessarily appealable even then. But my position stands, which is it doesn't need to be.
But is it wiped out as if it never happened? by the dismissal.
Is what wiped out?
Is the order, is the
No, it's not.
res judicata effect of a prior order in a case that's voluntarily dismissed without prejudice
Extinguished by the dismissal?
extinguished?
No. No, my position is no. The fact that it was a final order and that they had the ability to contest it at trial, and there was a finding in subsequent proceedings, and I think I do have case law in my brief on that, the fact that it is later resurrected, but that issue has been fully and fairly litigated with an opportunity for Mr. Williams to contest it. That's what collateral estoppel is.
Okay.
And then the last thing I'll talk about, well, my time's up. Thank you.
Thank you. Thank you both. Thank you both for your arguments this morning. We'll take the matter into submission and issue a timely decision. I hope you both have a great week.
You too.
Good morning. I understand that Attorney Gentry will be arguing for 10 minutes, is that right? Okay, and Attorney Hoff will be arguing for, obviously, 5, right? Okay, thank you, all righty. Good morning, Attorney Barnes, how are you?
If I may, I would like to reserve 4 minutes for a rebuttal.
Okay. Begin whenever you're ready.
How many cows were transferred due to page 41, the bill of sale? This court may never know. The record contains only page 41 of a labeled bill of sale. It references an alleged asset schedule. We don't know what that alleged asset schedule.
Wasn't that attached to the, to your opposing party's response to the motion for a more definite statement, or for the order for a more definite statement?
No, Your Honor. The Exhibit A asset schedule was not attached. There was an alleged Excel sheet that was attached for the motion for a more definite statement. However, that Excel sheet does not attach from that bill of sale. The bill of sale explicitly states an Exhibit A, which is an incorporated by reference document, which was not included. Now, Farrell does read on this case. However, Farrell, as the appellate's brief stated, is a conflict case with Midland v. Snedeker. As a conflict case, this case should be certified as a conflict case to the Supreme Court, or it provides this court the opportunity to revisit Farrell in harmonizing with the 2nd, 5th, 7th, and 11th districts.
Now, did I see in your, I guess, reply brief that if we don't agree to revisit Farrell and Farrell stands, that you concede that you lose under Farrell?
So we did say that Farrell controls and that it does have the summary judgment support. However, we believe that our case is distinguishable from Farrell.
Okay.
In Farrell, there was both an affidavit from the original creditor, there was an affidavit from the debt buyer as well. The court stated in their reasoning that Farrell was decided because there was 2 affidavits together with that bill of sale. Here, there's no 2 affidavits. We believe that is distinguishable. Additionally, we believe it is distinguishable as well due to the fact that Farrell involved a waiver case. This is not a waiver case. This is a Rule 56 summary judgment case. The appellant did not waive any arguments. They rightfully challenged from the beginning that there wasn't standing, that there wasn't documentation. As the court knows, we filed a motion for a more definite statement. In that motion for a more definite statement, the lower court specifically stated, absolute, you are to provide all assignment documents. Absolute did not do that in this case. They did not do that in their reply brief, as they stated. They only provided the one-page 41 bill of sale, which self-identifies as being page 41 of some 40-something pages.
So just explain to me the asset schedule again, because I thought there was an asset schedule that was.
So the asset schedule was never filed in this case. The bill of sale, the page 41 bill of sale says, to the asset schedule, Exhibit A.
So you're saying that the absolute resolution did not supplement its pleading with the bill of sale and a copy of the asset schedule?
That is what I'm saying, Your Honor. They
Okay.
did provide a alleged printout of some schedule, but that does not link it to the bill of sale. The bill of sale does not include the Exhibit A in either the Tufifi check affidavit or the first affidavit that was provided there. And so without that, the plaintiff Absolute would have had to present that for us to inspect to say, yes, we believe this is an authentic document. Under Rule 10006, we have the right to inspect that document to see the authenticity of that. That document was never provided to us, except there was a Excel sheet. That Excel sheet, we don't know where it came from. We don't have anybody speaking on that Excel sheet in any of the affidavits. So that Excel sheet could not be considered by the lower court or by this court. Looking at the two affidavits in this case, so the affidavits here, like I stated, is distinguishable from Farrell. Here, the affidavit, there was two affidavits provided by Absolute. The first affidavit was pretty much a very blank, generic affidavit. It didn't include any documentation with it. It didn't reference any documentation. It said, yes, this account, Mr. Marshall's account, was transferred through here somehow on this date. It did not include the bill of sale. It didn't include the Excel sheet or references to that Excel sheet. It was just a form document.
You would agree the bill of sale was supplemented?
The bill of sale was not supplemented in itself. They provided the Excel sheet. And so in their supplemental, what they did, they provided a bill of sale and a credit agreement, and then roughly 100 pages of statements. Those statements, however, do not control, because this bill of sale, as an assignee, the assignee must allege and prove. Even under Farrell, it stated that the assignee must allege and prove that documentation. The lower court assumed a documentation of that asset schedule. That asset schedule was never provided. That asset schedule was never identified by either affidavits. Therefore, it wasn't before the court, and the court should not ruled on that or included that in their ruling. Without that asset schedule, we need to turn and look at, so we cited in our brief, we cited Snedeker. Snedeker is a controlling case that states that
Is it controlling on this district?
so it is not controlling, it is persuasive in this district. However, that would, as the appellee stated, it would create a conflict case. They even stated in their appellee brief that Farrell would be in conflict with Snedeker. Snedeker is controlling in the vast majority of Ohio, 2nd, 5th, 6th, 7th, 11th, virtually almost all of Ohio except this district, which creates a conflict with the course of law. That's why we asked this court to take the extraordinary measure of revisiting Farrell to harmonize the districts.
You just argued to me why you still win even with Farrell in place.
Right.
So why would we want to do that if Farrell's been law for a long time in this district?
Right, so Farrell has been part of law of this case. However, when there's a conflict in the other districts and that does not harmonize together, that is a conflict case. Here we stated even under Farrell, we believe that this case is distinguishable because it doesn't have two affidavits. However, even in that instance, it allows a conflict with the greater state of Ohio. Anytime there's a conflict in law in the Franklin or in Montgomery, the plaintiffs or the debt buyers have to prove and allege. They can't just use a one-page bill of sale. In Snedeker, they have to prove that bill of sale. They have to prove the assignment. They have to prove the documents incorporated by references. This case does not do that. Even using Farrell, we believe that it is distinguishable. But however, if the court decides that Farrell controls, as you stated, we believe it's a conflict case that should be certified to the Supreme Court. as a conflict case, there is issues between the two districts, so the mini districts of Ohio. Snedeker is the controlling case in the vast majority of Ohio. Granted, here in Hamilton County, the plaintiffs or the debt buyers get away with not providing that documentation. Now, we believe that in this case, the reason it should be revisited is because that Farrell was probably wrongly decided. It allows an individual to be disadvantaged. They don't have the documentation. They can't prove the negative. The burden rests on the plaintiffs and the debt buyers. The burdens have all the documentation, or the debt buyers have all the documentation. They have everything to prove. And so to ask Mr. Marshall, say, hey, how can you prove that this doesn't exist? We can't unless we are able to review that document. We have not had that opportunity to review that document. Even with that alleged spreadsheet, we don't have the ability to say, yes, this is an authentic documentation. There's nothing from the original creditor. Even the affidavit itself, the Tufihi check affidavit, does not state their position within absolute. So how can we rely on documentation when we haven't been afforded the opportunity to look at that? That's why we believe that it was wrongly decided, because it unfairly prejudices the defendants, or in this case, Mr. Marshall. We believe that it is unworkable, because as it creates that disadvantage, how can anybody say, yes, we know that it's not in this case, we can prove it, show it. But they won't show it to us. They haven't provided that documentation. They haven't provided the exact asset schedule. They haven't even allowed us to review that. Even as the court stated, even in their response for a more definite statement, they failed to provide that full bill of sale. The bill of sale expressly states the asset schedule, Exhibit A. So there should at least have been an Exhibit A to the bill of sale. Granted, it could have just said, hey, there's some kind of documentation here. We should have been able to review that Exhibit A. Without that Exhibit A, how many cows did they transfer? I say cows, and I don't want to be facetious. I want to bring up the point that without that documentation, we don't know what was even transferred. We don't even know what assets were transferred. That's why Farrell is in conflict with Snedeker. Snedeker brings up the issue that the debt buyers need to prove that assignment, that the debt buyers need to show by evidence.
So just so I'm clear, your argument basically is that Midland isn't even entitled to summary judgment in the first place, so they didn't meet that first step of the shifting burden. Is that what you are arguing?
Yes, Your Honor. So they didn't meet that first step, so therefore, not meeting that first step, the court should not consider.
Not Midland, I'm sorry, absolute resolutions. Okay, sorry.
Yes, Your Honor, I understood what you were saying. Yes, but since they didn't meet that first step, they shouldn't even got to the summary judgment. I have 3 seconds remaining. I can finish with your question,
Okay.
Your Honor. Thank you.
I just wanted to clarify what you were arguing.
Thank you.
Thank you.
Good morning, ma'am.
Good morning.
Police Court Counsel Boyd Gentry for Applee. It appears that we're on track with a moving target. In the trial court, Marshall did not raise these objections or answers or responses because there was no objection, nor answer, nor response to the motion for summary judgment filed by Absolute. So we argued in our brief that these arguments and these defenses or claims are waived. They were not presented in any fashion to the trial court. There was no citation of the Snedeker case, if that's how you pronounce it. There was no citation to some evidentiary challenge or something under Rule 56.
So I want to make sure I understand. So the failure to respond to the motion, what impact does that have, if any, to the initial burden of the moving party?
It does not impact the initial burden of the moving party Absolute here. What it does impact is the appellant's ability to assign error to something that they did not object to, such as whether the affidavit and materials provided were in fact sufficient. Whether the reference to a page 41 in a document means something that was never raised in the trial court. Those objections that are raised now by Marshall are that the brief argued that there was no sale file or nothing attached beyond the assignment document itself. As the court, I think, noted, that sale file or the electronic spreadsheet was filed as part of the more definite statement as required in the trial court. It was filed. If Marshall at the time thought that Marshall needed more discovery to understand what that meant, to understand and make objections and arguments, Marshall could have sought that in discovery, could have raised objections in the trial court.
So that spreadsheet is the asset schedule?
Yes.
Okay.
Yes.
I was confused on his argument that it was something different.
Yes, and I think that's what the opening brief from appellant was talking about. But now it appears that appellant may have slightly shifted to raise an issue of the reference to page 41 on the actual bill of sale, as if that means something. If appellant thought the reference to other pages was important, that could have been fleshed out in discovery and motion practice in the trial court. By failing to bring that up in the trial court, appellant has waived the ability to say that was an error, because on the face of the document, there's no error. And I think that gets to Your Honor's point that the initial burden of Absolute was to demonstrate that it owned the account and what the account balance was. And just like in the Farrell case, Absolute filed an affidavit from someone who attached records, who attached the assignment and bill of sale. They attached the account statements themselves. The affidavit referenced this account number. The affidavit referenced the balance due and incorporated the assignment and the account statements into the affidavit. On its face, that meets the burden of Absolute and shifts it. Marshall then waived any objection to those materials by not raising them.
So, as far as the more definite statement, is it your argument that that becomes part of the pleadings, so it's proper summary judgment evidence?
It's certainly part of the pleadings. It was not that page of an Excel spreadsheet was not attached to the motion for summary judgment.
I understand that. That's
Correct.
not what I'm asking. I'm asking if your more definite statement, which includes the, it's sideways on my screen, the asset schedule Exhibit A. So are you saying that this was, because it was in your more definite statement, it was part of the pleadings?
Yes, it certainly was part of the pleadings in the case, yes.
Okay.
And that response to the court's, municipal court's order, I think necessarily implicitly makes it part of the pleadings in the case. So I think the ability of Marshall to object to the standard of Farrell being applied in this case is, he doesn't have the ability to object and say Farrell doesn't apply. Farrell does apply. Farrell discussed the affidavit from Midland, which was signed by someone named Crandall. That affidavit tracks very closely to the affidavit that's at issue here. There's no ability for Marshall to now say Farrell doesn't apply. There's no distinguishing fact that Farrell relied on. Marshall brought up that there was a second affidavit from Midland in that Farrell case, but there's no explanation for why that mattered. Why did there need to be a second affidavit? You know, there's nothing to suggest that this issue was brought to the trial court for the trial court to discuss and resolve. So we would maintain that Marshall waived that as well. Here, the affidavit of Ms. Chet contained an unequivocal statement that Absolute was the assignee and owner of this account by balance and account number. There's nothing in the record to challenge that. There's no objection to that. We would ask that the court affirm the judgment of the trial court. Thank you.
Thank you.
Morning, Your Honors.
Good morning.
David Hoff for the appellee here, and I'll be very brief about this. I don't believe that it matters how many cows were transferred pursuant to an assignment. All that matters is that this one was transferred to the assignment. What the appellant is looking for in the original Excel file are the hundreds and potentially thousands of other consumers' personal and financial information. We provide this consumer's information. That's all that's attached in the exhibit to the appellee's assignment. I have nothing else to say. Does the court have any questions for me regarding this?
I'm just going to ask the same question I've asked, which goes to the failure to respond to the motion and the legal effect of that in front of us.
And I don't believe that there is a material effect to that. The appellant did object to one affidavit from Ms. Laverne. The appellant did not object to the affidavit that the court relied upon in granting the motion for summary judgment. But the failure to object, I don't believe that otherwise has material impact.
Yeah. Thank you.
Thank you.
To begin with my rebuttal, the appellee stated that it doesn't matter that there was 2 affidavits in Farrell. It doesn't matter that there's only 1 affidavit today. What matters is that Farrell was decided. Now, Farrell was decided, but it does create a conflict with the cases in the Ohio districts. However, I would draw the court's attention directly to what was cited in the appellee's brief and why that affidavit matters, why that second affidavit matters. They highlighted and they quoted directly from Farrell and highlighted in bolded because Farrell relied on Zawick and Zawick, which said that an affidavit merely from the debt buyer is not enough. That's right before it states, Crandall's affidavit and the account statements together with Laverne's affidavit and the bill of sale were sufficient to establish the absence of any material fact. Together. The court explicitly stated, this court explicitly stated why they needed that affidavit. They said Zawick and Zawick controls that there needs to be something more. There has to be more than just an affidavit. Now, this court did ask, why? What is the opinion, or what happens that we didn't respond to their summary judgment? Did we waive any issues? Now, I don't believe, as the appellee's counsel stated, I don't believe that is an issue in this case, because we did waive it from the beginning. We waived the standing. We waived the issue with the documentation. The court even said you needed to provide the documentation. They didn't provide the entire documentation. Now, they did say they provided an Excel sheet. That Excel sheet, if you look at it, probably has 4 different actual file names in it. So how do we know what that is? Also, the affidavit, Ms. Check, did not read or explicitly state about those Excel files. Therefore, it shouldn't have been before the court. Now, the fact is that we did raise the issue. We raised it again, from the beginning, in our motion for summary judgment. We objected to the first affidavit, and we raised it. Now, the fact that it wasn't raised and responded in the plaintiff's motion for summary judgment, doesn't mean that we waived that issue. At summary judgment, the burden rests first on the movement to demonstrate entitlement as a matter of law. The absence of contrary evidence does not cure our failure. However, it doesn't bring that issue up. We still raised it. It's still in there. It's still in the record. So that's not an issue with this case. What is issue with this case is Farrell a conflict case? Does this court need to take the extraordinary measure to revisit Farrell, to harmonize it with the other districts? And if not, we still believe that our case distinguishes from Farrell. I'm out of time, Your Honor.
Thank you. Thank you to everyone for your arguments this morning. We'll take the matter under submission and issue a timely decision. I hope you have a great afternoon. Good morning. Good morning.
May it please the court, I'd like to reserve 5 minutes for
All
rebuttal.
right.
Your Honor, the trial court erred in denying Carrie's motion to modify child support for two primary reasons. It inappropriately and wrongfully applied the clean hands or unclean hands doctrine, and it failed to consider, I think, the most important fact that Carrie paid support not once but twice. The way she paid it was through the court order and then paid it in kind. In applying the unclean hands doctrine, the
Before
court...
we get into the inappropriate application of the doctrine, appellee argues that you never raised this issue in your opening brief.
I think the way I worded it, I put it in a reply brief, I said that the court's decision was wrong and inappropriate.
But you didn't raise unclean hands?
I didn't use the word unclean hands. I think twice I said the court's decision was wrong. When you look at the two-page decision Judge Flotman wrote, it's entirely based on unclean hands. So my entire argument was addressing the wrongfulness or the incorrect application of that case. In fact, if you look at the case Judge Flotman decided, that case talks about the court, in that case, the trial court using its equitable powers to determine if underemployment or voluntary underemployment was an issue. And it quotes part of this code section that says, in the interest of fairness or something else. I think that doesn't even apply here because I think it's not an equitable decision when somebody pays child support twice. Their obligation is to pay it once. So I don't think it's an equitable issue that one party pays support twice pursuant to order and in kind, and as a result, the other party, the obligee, gets a windfall.
So you don't think that unclean hands can ever be applied in a situation like this? Is that what you're arguing? That the court couldn't apply the doctrine at all to this motion?
I think it could if one fact was different. If this is a situation where, let's say, the day the order went on, she lost her job. When she loses her job, there's no wage deduction order. So she pays no support. She's not paying support. She has the child and basically continues in arrears by not paying the support. If the child's with her because of her misconduct, with not allowing the child to go to the father, I don't think she can then go to the court and say, relieve me of that obligation, the child was with me, because if the child's with her because of her unclean hands, that would be an equitable power excusing her from paying support at all.
I thought the child was with her because of her unclean hands.
It was, but she paid twice because of it, not once.
Okay.
Yeah,
I understand what you're
in
saying.
one of the cases that I cited, I believe it's Peterson, I think there were 3 children. 2 of them were with the non-custodial parent. The custodial parent filed and wanted an arrearage charge to the non-custodial parent, and the court said, you can't do that. She was providing support in kind, and because of that, you don't get it twice. So I think if she had financially profited or realized a gain from this, either by not paying support at all, then you could apply unclean hands.
Does unclean hands require her to realize a financial gain?
The way it's worded, if I remember the way the opinion it's worded, you cannot benefit from your own misconduct. So the way I interpret that is, she can't withhold visitation and then say, hey, the child didn't go with dad, I shouldn't have to pay support. That's the way I understand unclean hands would apply. But she paid it twice.
I want to ask you about the contempt finding.
Okay.
So that she was sanctioned $500 for the same conduct.
Correct.
And am I correct that she was also ordered to pay attorney fees as part of the contempt sanction?
For one of them, yes, but I don't remember if it was one or both. So I know at some point she was ordered to pay attorney's fees.
Okay. But she was sanctioned previously for the same conduct.
Correct.
Does that have any effect on the ability to use the unclean hands doctrine to deny your motion?
I don't think so, because my understanding is unclean hands requires, it's somebody seeking the court to use its equitable powers.
Mm-hmm.
Again, that would be relieving somebody from the obligation to pay support entirely, because legally, the non-custodial parent is obligated to pay support. Since she paid support through the support order, if that had been all there was, she's done what she's supposed to do. But she paid support through the order and then supported the child in kind the entire time period. So I think legally, I can't find anything that obligates the paying parent to pay support twice, which is in effect what she did. So I don't know that the contempt findings make her hands dirty for this purpose, because I think it's not an equitable decision. I think it's a matter of law.
That wasn't really my question. Her hands were already found to be dirty
Okay.
in the contempt proceeding, and she was already punished in that proceeding.
Okay?
So it seems like the judge is punishing her again by denying her motion. It seems like that's what she's, I mean,
In
that's
my
what I'm
mind-
trying to understand, is that she's already been punished for not allowing,
I think I misunderstood your question before.
Right.
If what you're, in my mind, because I don't do DR work, you guys all know this is outside my wheelhouse. I think that is, in my mind, the equivalent of double jeopardy. She's being punished twice for the same misconduct. She was held in contempt, and now she's being punished in contempt by being forced to pay support or incur support a second time.
that's what I was trying to understand, because I could
Correct.
see, like, if there wasn't, I mean, there's always this contempt ability for the father to go. and
Correct.
And in fact, he won a contempt proceeding, and she
Correct.
was in fact sanctioned for doing the exact same thing that the judge is talking about here.
I think in my reply brief, I mentioned that I don't think I used double jeopardy, but in effect said she's being sanctioned twice for the
You
same.
used double jeopardy.
Did I use double
Yeah,
jeopardy?
I remember that.
Because that's a simple thing my mind would go to. But the problem that legally I'll concede is I don't know of the civil equivalent of double jeopardy, that there is one. I think that goes again to the unreasonableness of the trial court's decision.
Well, I think the question is whether equitable relief is appropriate and whether there were other legal remedies in this case. And it seems like father availed himself of the other legal remedies through the contempt
Through the
proceeding.
contempt. I would agree with that. The other thing that I thought was kind of telling, when you look at father's answer to the motion, reply to the motion in the trial court, he cites no case law. And his argument is basically, if you were to grant Carrie's motion, you're going to set the precedent that you can withhold visitation and then profit from it financially. And I think that's what the trial court picked up on. But they cited no case law for that. It was just, in fact, his entire reply had no authority in it. And I think when you combine the clean hands shouldn't have applied, and then you look at what the trial court did not consider, nowhere in the two-page entry does the court even acknowledge, yes, she paid support through an order, and yes, she paid by having the child the entire time in kind, day to day. I think the court analysis was deeply flawed. And honestly, you guys don't have the history of this case. I think it was very much result-oriented.
So, Mr. Clerk,
Yes, ma'am.
did your client appeal the September 25th, 2024 order granting full custody of the children to Stephen?
No, because that was, as I understood it, an interlocutory order that would have not been final until that is incorporated into the decree of divorce. It doesn't become final till it's made part of the decree.
Wha-
The decree went on, the September 25th was the trial court's custody, parenting time, support order based on the custody trial. We
Okay.
hadn't got to the incorporating it, and I was told the decree is the final document, and so she would have had to appeal that. I think that decree went on May 23rd of 2024, I think. I'm not sure. It went on after September 25th,
Okay, thank you.
if I remember the dates right. I think real quick, because I'm almost out of my time, I think there was a change of circumstances that was demonstrated. I know that father contends there was not, but I think when you look at what the order contemplated, 50% time with each parent, and the support being based on that, whatever the reason it changed, there's a change in circumstances when one parent doesn't get that 50% time. So the order that's based on a 50% share is now unreasonable when one parent has 100% of the time. And I'll reserve my rest for my rebuttal.
Thank you.
Please the court. Good morning, Your Honors. My name is Blake Summers. I represent the appellee, Steve Kuiper. I'm used to saying appellee, and I always feel like I'm on the wrong side of the aisle over there. So we had the opportunity to brief this pretty well, and we had some motion practice prior to that. So we put a lot of writing in front of the court. With the court's permission, I'd probably focus on two things. One is jurisdiction, which we probably need to talk about, and two is something Judge Krause already alluded to, which is the idea of waiver. So for the jurisdictional aspects, as we stand here today, I am still not certain that there is jurisdiction over this appeal. The issue is that there is no more child support order to modify, which is the relief that was requested. It was the relief that was denied, and it was that issue which was appealed.
Well, this court is reviewing the trial court's order, which
Agreed.
was filed and decided before child support was terminated.
That's correct. No doubt about that. The issue is the child emancipates, right? They do it weird. It's either high school or 18. The child emancipates here actually 2 days before the decree of divorce goes on. And then that conceptually terminates the child support order. When we
So
look
you're
back-
saying that there was no jurisdiction with the trial court?
I'm saying there's no jurisdiction at this point because there's no jurisdiction to grant the relief that appellant seeks, which is to overturn a denied modification because there is no order to modify, because the emancipation of the child terminates the order. It would be like appealing the conditions of your probation in municipal court after the term of your probation has ended. If we're going to do criminal law analogies, maybe I can do some of these okay.
So let me ask you, I'm going to give you a hypothetical.
I'll try.
All right. So there's a situation where one parent has full custody of a child because the other parent has left and is not findable. After the child turns 18, they finally find the dad. Could the mom not, or the other parent, the parent who had the custody, could that parent not seek back child support? Because that seems to me that this is kind of in the same vein.
So I hate giving you the lawyer answer of it depends, but I think it actually really does depend because there are certain statutes that deal with that issue in terms of a child support, whether it is or is not entered before the child is turned 18. And then I think, it's been a long time since I've looked at this, but I think that at a certain point, once the child is over 18, I think the child actually develops a claim rather than the mother because mother.
Parent.
Sorry. It's
I did it too, so
2006,
don't worry.
sorry. I think the child actually develops a claim at some point, not the custodial parent because they're over the age of majority. It's been a long time since I've looked at
Okay.
that, but it came up in juvenile court once. But I think the concern here is if we look at the Castle decision, right, which is not about this at all, but is about termination of entries and preservation of jurisdiction over a child support order. It frames this as a jurisdictional issue saying that the jurisdiction of the court extends beyond the 18th birthday of a child only when there is a special needs child. And so if it's framed as a matter of jurisdiction, and if the order was already
But
terminated.
again, I want to go back to my question, because you said the jurisdictional issue is here, not with the trial court, is that right? Okay,
I believe yes.
because the trial court always has the authority to enforce its orders.
I would largely agree with that. So it would have the ability to enforce, but I think enforce and modify are two different things. So
Okay.
if a parent owed $100, $1,000 of support prior to the child emancipating, I think the court probably still has jurisdiction to enforce its orders via contempt. On the other hand, after the child turns 18, I don't think the court then has any jurisdiction to modify a support order, because the support order doesn't exist anymore, which is what appellant is trying to do, which is I think what creates the jurisdictional problem, is that we're trying to modify something that simply doesn't exist.
So we couldn't retroactively modify it for the months that it was in effect?
I don't think there is an order to modify anymore because it was terminated effective as of the emancipation of the child.
Really,
I think,
it sounds like what you're really arguing is whether it's moot, not jurisdiction itself.
I wish I could have written down the number of times I sat at my desk and stared out my window thinking about this. I don't think it's a mootness question. I think it's a jurisdictional question, because mootness means there's no relief that could be granted. And I think because appellant has requested this extraordinary remedy of backdating the retroactive date of the support modification, I think that probably avoids mootness. And maybe I didn't do a good job. I tried to clear some of this up in our motion practice in our brief, but I think the idea of mootness is that it's an abortion case and the child has been born. That's why we have to get to that exception. That's what I always think. I don't want to do this horrible issue when we're talking about child support in court, but that's what I always think of as mootness and the exceptions to the mootness doctrine. So I don't think that this issue is moot. I think the issue is that the underlying order, which the appellant seeks to modify, is something that the court still has jurisdiction over because the order doesn't exist anymore.
So you're saying that in this particular case, mother's trying to get back child support paid to her through, that's what the motion's trying to do. I mean, she's trying to modify it, but the idea is it's retroactive, right? She's trying to get back child support.
Trying to reduce what she owes. So the mother was paying her guideline amount through the court's order.
Yeah.
And has made an argument that because the child was living with her full-time.
That she doesn't owe child support on that child.
That she shouldn't have owed child support on that child. So it's not to get back support, it's just to eliminate somehow what she had paid and then take that amount that she did pay for that child and eliminate it for the other child.
So I want to make sure, when you're saying the order doesn't exist anymore, it's because the mother had complied with the order as written, and there was nothing left.
The order
With
does not
regard to the
exist anymore
order.
because of the emancipation of the child, regardless of the compliance of the parties at the 18th birthday and/or graduation
Okay,
from high school.
so that's
the
what I
order
wanted to
terminates.
clarify. So if it's because of the emancipation of the child, then what, under your argument, when a parent has not complied with the child support order, then there wouldn't be jurisdiction in front of us once the child is emancipated.
Again, the distinction between enforcement via contempt and modification of an order that doesn't exist anymore. And we're not talking about a contempt here, because I think the Domestic Relations Court does have post-emancipation jurisdiction to enforce via contempt a non-complied with child support order. I do not think the Domestic Relations Court has jurisdiction post-emancipation to modify an order, because I think the emancipation terminates that order.
So in essence, what you're saying is emancipation, the legal effect of emancipation is that the order no longer exists.
I think that's for purposes of modification, yes. I think I had to keep making that distinction, but yes, I mean, I
But
think,
going back to what I was asking you, so if she would have won,
okay, which part?
if she would have won her motion to basically not have to pay child support for this child, and then also somehow she's looking for a retroactive order, right? It's like over $3,000 that she said she shouldn't have had to pay.
Correct.
How what would have happened with that 3,000? Would it have been applied to the other child that she would owe child support on? And she still owes child support on this child?
I think what generally happens is that the CSEA, the Child Support Enforcement Agency, is statutorily required to disperse any money that it gets within a certain amount of time. I think it's in the Ohio Administrative Code. So what happens is a credit is created on a child support account. It doesn't get paid to the obligor. What happens is it sits there, and then as as the remaining child or children reach the age of majority, the CSEA does a calculation and stops the withholding of the obligor's support obligation sooner than it would have if it continued all the way to emancipation.
So it would have been credited to the other child?
That is my understanding, and I think what appellant is requesting.
Okay, all right. Just trying to figure out how that works, because I'm trying to understand why, just because she was emancipated, now the mother doesn't have an appeal on this. I don't know, it's just not jiving in my brain, but I'd like to hear your unclean hands argument.
And to be fair, I could be wrong. I can't find a single case that really addresses the jurisdictional aspects of this. I don't know that I found a single thing that I thought was like, oh, eureka, I've got it. This is exactly what I needed. But I don't think that if there's a jurisdictional issue in a case, we can just assume it's okay. So, I mean, if the court tells me I'm wrong, then I will be wrong. I've been wrong before, and I'm sure that's going to happen a lot. But in terms of unclean hands, I think Your Honor brought it up. I think the issue that we have is that this is the basis of the trial court's decision. And it's been waived by appellant in these proceedings. I understand from the reply brief, appellant is taking the position that like, well, kind of my whole brief is about unclean hands, and so we're saying the whole decision was wrong, but I don't think that's an accurate read of the appellant's brief. The appellant's brief is pretty exclusively dedicated to the idea that there was a change in circumstances that would substantiate a modification in child support, and there was also a change in of circumstances that would substantiate backdating the modification to a date prior to when the motion was filed.
But he does point to a part of his brief where he said that mother was not attempting to benefit financially from her own misconduct.
Mm-hmm.
To me, the whole idea of her misconduct goes to the unclean hands
I agree.
doctrine. So I feel like it's mentioned.
If that is how the court reads that limited paragraph,
How do you read it?
I read it as waiving the doctrine of unclean hands and how it applied, because the idea of change in circumstances and the idea of whether the trial court was just wrong is very different than arguing the merits of whether the doctrine of unclean hands was appropriately applied or not. I also don't think that the appellant's position that there has to be some demonstration of financial gain is supported by the law that interprets the doctrine of unclean hands. Certainly, I think that can be part of it. But I don't think my client is required, or the court was required to find that there was a financial incentive involved prior to the time that it can apply.
That's probably right, but what about the contempt finding? How do you address that? Because mom was already found in contempt and sanctioned.
So if we're talking about double jeopardy, I would say separate sovereign rule, like criminal procedure 2. I think they're two different things. I think they're two different wrongs, and I think they're two different remedies.
But wait, so this unclean hands doctrine is an equitable relief.
Agreed.
And it's appropriate when there's other legal remedies that are not available, right? So if there's other legal remedies that were available and imposed, in this case contempt and sanction, how is the judge able to use unclean hands in this particular motion?
It's a good question. I know what the court's talking about. There's this general idea that if there's a legal remedy involved, that unclean hands generally won't apply. I think the problem is that the legal remedies, although they were available to the appellee below, did nothing. She had already been found in contempt twice.
Well, she was ordered to pay $500. Then my question to your opposing counsel, and he wasn't sure, was I saw a $35,000 attorney fee order for contempt.
I would have to go back and look at exactly which order it was. I'm sorry,
Okay.
I can look when we're done, but I don't recall.
Okay, I thought that the contempt sanction included a $35,000 attorney fee order.
I think it does. If I had been the trial court attorney, I certainly would remember the day that I was awarded $35,000 in my fees. Regrettably, I was not. But I think regardless, I think there is ample evidence in the record for the finding that the court made. I'm not going to stand up here and read my brief, but I think if the court looks at the entries, the contempt entries, if the court looks at the custody entries,
What I find interesting is the idea that, that the sanctioning, that the holding of contempt, the court basically enforcing its order, right? That is the basis of the determination of the unclean hands, right?
I think some of the information that is part of the contempt decision also forms, I would have to say that the court's information via that contempt forms part of the basis of the court's decision on unclean hands.
Right, so I find that interesting to then would that be a bar to the unclean hands?
Again, I don't see it as a bar, but I see it because it's two different remedies and it's two different wrongs. So much like double jeopardy or separate sovereigns, right? One is based on a person
So one
not
is, so
complying.
one is based on not doing what the judge told him to do, right?
Right.
Told the individual to do, right?
Correct.
And the other is whether the person is entitled to the modification. And then, so play that out for me, how
I
they're
think the
different.
second is whether the litigant is entitled to seek relief in front of the court based on the situation that they created. It also looks like my time has expired. so-
I have.
it's okay. Go
Actually, I have a question I want to ask. Everything that we've been discussing, other than jurisdiction, doesn't matter if we don't find a modification or a change in circumstances. So if we,
No, probably not. Sorry, I had to think that through. So, I think even if all the procedural difficulties are resolved in appellant's favor, I think if the court were to find that there was not a change in circumstances and address the issue on the merits instead, no, I think that would resolve the case on the merits of the change in circumstances, and the trial court would still be affirmed, even though it would be on different grounds than the trial court set forth, which this court is entitled to do.
thank you.
All right, thank you
Your
so
Honors,
much.
thank you very much. Have a good rest of your day.
Thank you.
You'll give me one extra moment. I knocked off one of your buttons here. I am sorry about
It's
that.
okay.
Thank you.
Attorney Clark, I'm not sure that I've done the timers correctly. How much time was it that you reserved?
42 minutes. I asked for 5.
Okay, thank you.
The first thing I'll address is Judge Bach's question about waiver. On page 14 of my brief, I wrote, "The trial court concludes modifying Carey's support obligation would, quote, create a precarious precedent wherein parents would be encouraged to disobey the court's parenting time order for their own financial gain," close quote. Then I go on to say, "But the trial court's conclusion is an abuse of discretion and simply wrong." Then also on page 14, and I think this might have already been mentioned, I argue this is not a situation of a parent attempting to benefit financially from her own misconduct, but rather a parent who has already paid in-kind support for their child not being required to pay support twice. So I think, without using the name unclean hands or the label, I think I addressed it through that. I do want to answer a question that you just asked, Mr. Summers, and I probably shouldn't, but I will. If you all decide there was no change of circumstances, it doesn't matter about anything else, because in order to prevail on the motion, I would have had to show a change of circumstances.
Was there a change in circumstances? I mean, I read your briefing, and I guess my major question is, to qualify as a change in circumstances, does it have to be not contemplated at the beginning, like when the order was entered?
That's, and I don't remember what pages in my brief, but that was the definition I found. It has to be something that was not contemplated by the trial court at the time of whatever order we're talking about. And at the time of the initial order, or the one that we're talking about, it was supposed to be a 50-50 split with time, and then child support would have been calculated based on that amount of time for each party. When it goes from 50-50 to 100% to 0, that would change the child support obligation.
So before the order was entered, what was the parenting time split?
I don't mean this at what point in time.
Before, let's say the 2 years before that order was entered, what was the parenting time split?
It depends, and that gets into a lot of the tortured history of this case. They had been separated for approximately 2 years before any divorce was filed. They had informally worked out.
Well, this was entered in 2025, correct?
Right. September 25.
So let's say 2024 to September 2025.
They were using a rotating schedule, and this goes to one of the initial contempts. Kayla, the 18-year-old, had refused.
Don't use names.
I'm sorry, that KK had not seen him at that time either. She had not spent any time with her father since, I think, October of 20, despite what the parenting time order was.
So how was it not contemplated then?
Because the judge's order, which is memorialized in the decree, but the order is what was the basis of everything here, contemplates that they will see each other on a 50-50 time split. Now, whether that was reasonable for the judge to make based on the history of the case, that's a very different issue. But her decision after the custody trial was KK goes with dad 50% of the time and mom 50% of the time. And I calculated support accordingly. So whether reality or she thought that order was reasonably going to be followed, I don't know. But she calculated support based on her order of an even time split.
Okay, thank you.
Oh, and I did look, the decree went on May 23rd of 25. The September order was Judge Searcy's custody order. We originally were rolled to Judge Searcy, and then we went to Judge Sunderman, and then we ended up with Judge Flotman, which is who has the order that brings us here today. And then the only other thing that I'll mention with respect to jurisdiction, I think that if there's no jurisdiction in this court to modify this order, there's something terribly wrong, because this court has the jurisdiction and the authority and the obligation to review orders and decisions of a trial court. If you think of this, if it had been the other way around and father had not received child support and filed a motion for back support under the same timing, he's then left without a remedy. And I think the special remedy provision, because this affects a substantial right, only an immediate appeal will protect. There is no other way for this to be reviewed absent this court having jurisdiction for the appeal. I talked about waiver, I think I hit everything. So we just asked you to reverse the trial court's decision.
Thank you. Thank you both for your arguments this morning. We'll take the matter into submission and issue a timely decision. Have a great afternoon. Good morning.
Morning, Your Honors. I'd like to reserve 4 minutes, if I may. Aaron Herzig on behalf of appellants. May it please the court, we've dealt with a lot of consolidation cases. This court has yet to find one in its issued decisions that it disagrees with. I find it hard to believe that we have not found this case today. If consolidation was okay here, I don't know what the limiting principle is. Ms. McClendon is a teenager with progressing scoliosis that eventually would press against her vital organs. Ms. Brorin is a septuagenarian with chronic back pain over many years. They have different histories, they have different procedures. There is no common tie. Some of the common tie that this court has been concerned with are the statements that Dr. Durrani allegedly made to plaintiffs and that those were the same over time. There is none of that testimony here. We simply think that there was no good reason to consolidate this case, and this court was skeptical already. In the writ of mandamus and prohibition that this court reviewed, Ms. Brorin and Ms. McClendon intervened. They are actual parties in that mandamus action. This court discusses its skepticism about the court's proceeding there. As you know, in that case, Judge Reese admits that he has not done any Rule 42 analysis. He tells the court this in his briefing. This court gives admonishments to Judge Reese saying, you've got to tell us what the common facts and common law are. It still does not happen in this case. So this court had an opportunity to deal with it in the mandamus and prohibition action. It doesn't because it believes there is a remedy after trial, a legal remedy on appeal, which of course is an element for a writ, and that's where we are today.
Attorney Herzig, I understand your arguments, okay? So let's say that we were to agree under Rule 42. Does the analysis end there? What happens next?
Certainly, at minimum, you would reverse for a new trial, new separate trials, in our view, on this case. The other problem you have here is Ms. Brorin dies in 2014. Her estate is open. Her husband is the trustee and administrator of that estate.
What I'm saying is this, so Rule 42, you would agree that it has may language, right?
Yes, if there are common questions. I mean,
Yes.
the shall is, you shall find common questions of law or fact. Once you do, you may consolidate.
Okay. And let's say we were to agree that it should not have been consolidated, okay? My question is are we done? Is there any other, any sort of harm analysis or anything that follows before we get to the determination of new trial?
No, Your Honor. I think the harm is baked into the Rule 42 analysis, just like it is in the Rule 23 analysis. If these two things should not have been tried together, then the court must reverse that. You can't just say, oops, you get a redo.
I mean, I find that interesting because in the criminal context, and I think we can agree that a civil party is not going to have more rights than a defendant, right? In the criminal context, we do engage in a harmless error analysis. And in that, we're talking about joinder here, we're talking about consolidation. So I'm trying to understand this, and as you know, it's not like there's a lot of, this is a bit of a novelty. Not a full novelty.
Oh, well, so on that point, Your Honor, we do think it is a novelty. This is the only court of appeals that we can find that consolidates medical malpractice cases. We've raised this before. We have never found one. This court has never found one. Appellees have never cited one. The Sayuda case that goes back several decades is the only case. My colleague will tell you that
Well,
they tried a
I'm
six
talking
plaintiff
about the
case
juncture that
that
we are
hasn't gone
here.
to a court of
Yeah.
appeals.
And
yet.
I understand, and that goes to your argument, so I like for us to just go like, okay, let's assume that we agree with you, right? So that goes to whether we should agree with you.
Yeah, so I think a couple things. I think, first of all, I stand by my answer. I think the whole point of doing the questions of law, common questions of law and fact, really does get at the question of prejudice in the first place. But even if this court wants to do a prejudice analysis, I think it's very clear here that there was prejudice.
Okay.
The fact of having, you have already ruled that evidence of other medical malpractice cases should not come into any other medical malpractice case. You are not alone in that. That is common in Ohio, in the federal courts throughout the country, of course. The same effect is here. The jury from the beginning knows that there are two people claiming medical malpractice. It's actually worse here where you have such divergent patients because they start, it's easy for the jury to start to think, oh my goodness, every surgery this guy does must be a problem. The other challenge you have here in terms of relief is the real party and interest issue with the Brorin estate.
Before you move on to that, though,
Sure.
just so for the purposes of this case, I know that you all are very frustrated with the Jones decision and our subsequent decisions, have been trying to get this up in the Supreme Court. Supreme Court's never taken any of these cases yet, right? on this issue?
That's correct.
Okay, so is there a way for us to rule in your favor? Because you always ask us to overrule Jones without overruling Jones or our prior precedent in this case.
Sure, Your Honor, and of course, part of the challenge that we all have together is that we are writing briefs, then you are making decisions, and the timing is sometimes off. You have several additional precedents here. But as a couple of us discussed a little more than a month ago, in our view, Jones at least has the idea of same type of surgery and same place in the back. This certainly is distinguishable from that. So I think you've got lots of reasons to distinguish this case from others and from any other case you have. There's always, of course, we do always raise a harmlessness analysis to Judge Zayas's point, and that is on a case-by-case basis. And in this particular case, I mean, I don't know how much time you want to spend on the other errors, but there are a large number of them here. But I think every one of your cases so far has necessarily been on an individual basis. This court does not have a blanket ruling that medical malpractices can be consolidated on this basis.
So there is no need for us to do what you typically ask us to do, is overruling Jones and other precedent in order to rule in your favor in this case, is what you're saying?
No, we think that is the right answer. We do think there has been a problem with every single consolidation. But each one is taken on its own, and I think I don't think you have to overrule it to come to a decision here. In fact, like I said at the beginning, one of our concerns is there must be limiting principles at some point. This was a discussion some of my colleagues had with the panel last week that folks were focusing on, and Judge Bach has focused on that in her concurrence or several months ago. We don't know what those are. This would be a place to start laying that down. And I would point back again to the fact that we did seek mandamus and prohibition. One of the judges on last week's panel was concerned about the elapse of time. We provided the opportunity to nip this in the bud. The court, for good reason, said it couldn't. But here we are with our only opportunity to get a fair trial. So that's why we're here in these cases, and we think, yes, you can make these cases, you can do this on an individualized basis without overruling any particular precedent. We think they all can sit together. Getting back to the relief for a moment, the Brorin State closed voluntarily. It settled. It terminated. All of its affairs were wound up. That would have involved many parties not before this court. In 2021, it was raised by trial counsel that there was no longer a real party in interest. The estate no longer exists. There is no one to bring forward these claims. On the last day of trial, as the case is going to the jury, the lawyer for the estate up in Auglaize County opens the estate, gets a nunc-pro-tunc order from the probate court in Auglaize County to open the estate specifically for the purposes of allowing the Brorin estate to be a real party in interest again. Literally, as the jury is deliberating, suddenly a real party in interest has arisen. We think there's clear precedent that that's wrong. I'll point you to the Lorenz v. Bowen case, 2002, Ohio 3415, that we cite in our brief. We think it's really a pretty straightforward error here to allow a real party in interest to arise during deliberations. There was no one. There is no entity to carry the case forward. So if you were to remand on consolidation, you don't actually have to separate the cases because you should dismiss the Brorin case because there is no real party
Can I
in
ask,
interest.
though,
Yeah.
about Civil Rule 17?
Mhm.
Because the Lorenz case that you say doesn't reference or cites the Civil Rule 17, and I was just curious, my understanding of that rule is it allows a plaintiff the opportunity to fix the problem, which seems to be what they did here.
It does. What that case, I think a few things are very similar to our case. One is in both cases, the plaintiff acted voluntarily to terminate the estate. We have, and Lorenz goes our way, of course.
It does.
Yeah.
But it doesn't talk about Rule 17, and I was just curious.
No, but it is a rule, I think it's fair to say it's a real party and interest case. I mean, the question really is whether the estate can be, can arise again after being settled.
That's where I'm struggling on this, because, you know, whether that was an appropriate nunc-pro-tunc order, I don't think we, the First District Court of Appeals, can't decide that, right? We just have to accept the fact that they somehow got this estate reopened, don't we? We can't judge this nunc-pro-tunc order.
Well, I think you can, Your Honors. I mean, when you think about, if you can't, then no one can. They open an estate in one day and get a nunc-pro-tunc order the next. They do it specifically to affect the case that is now before
So you're saying
this court.
we could reject that nunc-pro-tunc and say that was
think-
incorrect?
I think you can, I think you can understand that it is, in fact, that it was an improper order, and not particularly be guided by it.
So my question on Rule 17, you agree that the plaintiffs could have tried to fix this, but what you're saying is that the way they fixed it was incorrect.
Well, in part, it's a waiver. It's waiting to, I mean, it's waiting too long. Yes, the trial court had a motion for directed verdict in front of it. It should have simply entered the order. There was no real party in interest. It shouldn't aid a particular party that intentionally closed an estate a year before and knew full well that.
We would have to reject the nunc-pro-tunc order. We would have to say that that was an invalid order.
Well, I don't know that you have to do that.
Okay.
I don't think I think you can do that. I think it was, I mean, if you look at the request for the order, it says, this is a new thing. This is a new asset. The claim was brought on behalf of the estate. It is not a new asset. That court was
We can't review
deceived.
something that's not in this district.
So,
Just, you know, we were like minutes past this time.
what you would be allowing then is someone to run into a different court and affect a case that you can
But wasn't the
review
estate-
without reviewing it.
Wasn't the estate opened and probated in Auglaize County?
And yes, and closed.
So then it wouldn't be somebody running to a different county. I mean, that was the county where the estate was located. How can we review a trial court's judgment from Auglaize County?
So I would go back to the fact of what that means for this court and how this proceeded here. What you're suggesting is someone should have moved to intervene in an estate that was reopened. It's unclear whether anyone knew that that estate was reopened. Who are the parties to that appeal? What avenue does someone have to challenge it other than here, when the specific purpose of going was to try to revive a case that was obviously dead?
I understand your frustration. I totally get that. But again, we cannot review a trial court's entry from a different county.
Okay, thank you. Thank you for your argument. We are minutes past your 10.
I will answer
Like
your question on-
beyond minutes. And Attorney Statman, I will make sure that you have a full and fair opportunity, okay?
I'm sorry, I couldn't hear you.
I said I will ensure that you have a full and fair opportunity,
Thank you.
all right?
I'd like to start out with a few things that are in the appellant's brief that are not properly represented to the court. And the first, if I get my throat clear, is this issue on consolidation. First of all, the Supreme Court has never taken one of their appeals to reverse or affirm any of your cases on consolidation, not a single one. Additionally, this case involved the same kinds of surgeries. Clendon was a T5 through T12, T3 through L4, and Brorine was T3 through T10. Thoracic surgeries are the most rare of all surgeries. And here we have 2 thoracic surgeries performed on a spine. Sure, one was scoliosis, the other was other spinal issues, but they were surgeries performed on the thoracic spine. Thoracic spine doesn't have a lot of problems because it has the ribs attached, and that further stabilizes and makes the thoracic spine not move as much as the cervical and lumbar spine. So statistically, you don't have as many problems. But these were on the same areas of the spine with the same experts except one. They want to tell you, we had Dr. Melman, we did. They want to say Dr. Melman wasn't disclosed because his deposition was taken in all children's cases. But what they don't tell you is that in January 3rd of 2019 and August 10th of 2018, Dr. Melman was disclosed in all of the Durrani cases as an expert witness, along with all our expert
Have you
witnesses.
moved on from consolidation?
What's that?
Have you moved on from consolidation? It sounds
Yes,
like-
yeah.
Because I just was going to ask, you're talking about the same experts, but it looks like you have, Dr. Bloomfeld was testifying for one, and Melman was testifying for the other, right? So you
Right.
don't really have,
We had the same
you have Dr.
Saney,
Saney for,
and then we had Bloomfield and Melman.
yeah, but Bloomfield and Melman were more toward the, they were the surgeons, right?
Right, and we've had
Okay.
Bloomfield and Melman, and we've had Melman and Wilkie on multiple occasions throughout this litigation.
Try to remind me, were there situations where their testimony was like for the different plaintiffs, or did they both testify about
The
each?
different plaintiffs in
Okay.
consolidated cases. And Dr. Melman was fully disclosed. And
So,
I understand.
so you're talking about surgeries, like, you're saying it was on the same area of the spine, but were the surgeries the same? The surgeries weren't the
The
same.
surgeries were different,
All right, so it's different surgeries
on the same level.
on the same area, but different surgeries. You have different experts for each one,
No, we
right?
have.
And different conditions
no,
for
we
each
have
one.
one expert that's the same on both.
And then a different one
then a
for each
different
on the,
one
on
on
the
those.
surgery.
Right.
Because Sani's the radiologist.
He is a
He can't testify
neuroradiologist.
about the surgery.
He-
There's aspects, but he can't, you had surgeons testify about the surgery.
Correct.
Okay.
Dr. Saney can testify about certain aspects of the surgery as a neuroradiologist because he has to look at them during the surgery in fluoroscopy.
No, I
and after
understand what
the
our
surgery.
prior precedent said about him, but
Yeah.
I'm just trying to understand the, the appellants here are not asking us to overrule prior precedent. They are distinguishing prior precedent. And so I'm just trying to look at the differences between the two cases here. And so you agree there's different surgeries, even though it's the same area of the spine. There are 2 different experts, or one for each plaintiff. And there are, the plaintiffs are very different here, right? You have a young woman who has scoliosis, and then you have an older woman.
Well, we never have people of the same age. I mean, we often have people in their 40s and people in their 70s.
But people with the same conditions you would have in prior
No,
cases.
the same areas of the spine, but everybody's condition is not the same. We have 500 people here that we're trying to get justice for through the system.
Right.
The issue on consolidation is not down to every aspect of the case being identical. You're not going to find them in the same age group.
So what is the common question of law or fact here?
Did Dr. Durrani breach the standard of care in performing an unnecessary spinal surgery on the thoracic spine of these 2 people?
So it has to, in your mind, it has to be the same area of the spine. And then if it's the same area of the spine,
No.
we're fine, even
I
if the
think-
surgeries are
No,
different.
you asked me what it was here.
Okay.
I talked about this last time, and I told you about how C1 and C2 are completely different types of vertebrae. But the vertebrae in the rest of the spine, leaving out the sacrum, are identical in their anatomical makeup, with the exception of their size. And so what you do to fuse a C6-7, there's a choice of 5 different types of fusions, for instance. Those same types apply to L4-5. So no, it's not, this case was thoracic only. But unless you're doing a C1-2 fusion, which in Dr. Durrani's world only comes up in Ehlers-Danlos syndrome cases, which are cases of hyperactivity, which is similar to circus freak. They can turn their heads like an owl, for instance. You're doing the same types of things. You're doing foraminotomies, disectomies, you're doing different types of fusions, T-lifts, D-lifts, different ways to fuse the bone and get the same result. So you're never going to get exactness in terms of grouping the trials. And this idea that you're told, well, you have all ruled that other medical malpractice decisions don't come into evidence in non-Durrani cases. Well,
But where's the limit, though? I mean, I think what they're trying to do now is say to us, well, if you're not going to overrule your prior precedent, you need to draw a line. Where is the line?
I just need to finish that last sentence,
Yeah,
then
go
I'll
ahead.
answer that. And I've lost my train of thought, so I'll move on and come back to that.
I'm just curious, where is the line?
Well, I
And-
think we talked about this a week or two ago. In federal court, we did 6. It took 6 weeks. In state court, we've done 1, 2, and 3. 1 generally can get done a week, it usually takes 6 days. 2 and 3 get done in 8 days. We usually go Monday through Thursday, and then we pick up again Monday through Thursday. So it seems that the limit has already been set by
But you're
Judge-
talking about number, I'm just talking about the differences in the cases.
How many differences?
Yeah,
Well, you
because I mean,
wouldn't try-
you saw what they're saying, the differences that they've laid out in this case between the two plaintiffs.
Oh, I don't see the differences for consolidation. Spinal surgery,
Is it just spinal surgery in general?
I think it's,
Or is it the area of the spine?
No, I have a problem with the area of the spine. It just so happens that in this case, when you asked me the question, what is the issue? I said, were the thoracic spinal surgeries necessary? Because they are thoracic spinal surgeries. If you ask me one that had a cervical spine and a lumbar spine, I would say, were the spinal surgeries necessary? I'm telling you that until you get to C1-2, or you're doing spine offshoots like sacroiliac joints in the pelvis, the process is the same.
Okay,
They
so
are the
if
s-
it were a doctor that was prescribing unnecessary surgeries for like hips and knees, would you be able to combine a hip and a knee?
No.
Okay, so it all has to be a spinal surgery.
Right, I wouldn't, how could you put a brain operation with a broken toe? That doesn't make any sense. But you certainly could group a doctor that did a left lobotomy with a right lobotomy if it were an operation on the brain. You could certainly do a Hoffman's device setting of a broken arm with a Hoffman's device setting of a broken leg, because the way you set a Hoffman's device in an orthopedic case is identical, whether it's going into the arm as an external fixation. And if you don't know what it is, it looks like
But
a...
the surgeries here you said were different. You said it was the same area of the spine, but different surgeries?
they're different surgeries, they have similarities.
Okay.
They are not 100% the same. But we're going to, I think that in any medical situation, you're going to find nuances that if you wanted to come up with a rule that said there'll be no consolidation, well, then you say things like you can't have a D-lift with a T-lift. You can't have a thoracic spine with a cervical spine. And you can destroy the rule if that's what the goal is. But you've got another problem here. I mean, you collectively as the court. Justice has to be served, and timely trials need to be given to more than 450 litigants. Now, how is that going to happen? Well, bring in more judges. When we started this, every common pleas judge was assigned some of these cases. They didn't want to do that. They gave them all to the administrative judge. And then there was the problem with Judge Ruhlman running off on a lark of his own, according to what I read in the appeals. That was before my time. So the Supreme Court assigns one judge. Well, how does one judge get through 450 trials in a lifetime? We have had over 100 dead plaintiffs. That's not serving the ends of justice. We've got Dr. Durrani, and I love reading these briefs. Dr. Durrani moves the court to do this and do that. No, Dr. Durrani doesn't ask you all to do a thing. These two gentlemen have never spoken to Dr. Durrani, yet they write about...
I think it's pretty commonplace to...
What's that?
I think it's pretty commonplace, though. I mean, when we're writing opinions, we don't put the counsel's name, we put the litigant's name. So to me, that doesn't seem to be
But
a big deal.
but counsel in a case doesn't have the right to make moves under the ethical rules without consulting with the client.
Does that have any impact on what we're deciding today?
Well, I think it does. I think it does. Dr. Durrani's not commenting on the similarities. They're telling you this, that they're not similar as lawyers.
So do you
You know,
want
we've
to talk
put-
about that nunc?
What's that?
Do you want to talk about that nunc pro tunc entry?
They should have intervened in the Augalais County case and objected to it. That's
How
their
could they have-
choice.
Wasn't this done like overnight? The nunc pro tunc was put on, like,
But that was up to that judge.
Overnight?
That was up to that judge. And you know what? This is much to do about nothing. And I'll tell you why I say it that way. This case was pending for a long time and had an open estate. That estate got closed without the realization of the people in Augalais County that this trial still needed to be completed. So when that was brought up, it was fixed. It didn't cause them one bit of harm, whether they started the trial with or without that order. They had been involved and practicing in the case as if the estate was open the entire time. So a technicality was fixed overnight, if that's how it went down. I don't remember if it was overnight or a day or two. But this is just a red herring in the case because all I see are repeated Hail Marys. Like, here's a Hail Mary for you in this one. Dr. Saney's PowerPoint refers to his being indicted for crimes. No, an exhibit does. And you know where we got that exhibit? From their side of the case, years ago. And you know what the rule is? If it says something about Dr. Durrani in there and they don't like it, they have to redact it out and then show the court, you know, hey, we got this thing where it says Dr. Durrani's an evil man. Redact it out. Their trial lawyers didn't do that. And when we caught it, I mean, it's in the record, and it looks like this. I highlighted it. It's not even that, it's in the middle of a letter that got put up real quick and got taken down. And so they write a brief with this bloviated reasoning that, oh my God, you can't undo this. Well, first of all, it's highly unlikely anybody saw the one line in the center of this letter. I mean, I highlighted 4 lines, but it's really just 1 line, so I can just find it quickly. That's their obligation. We got the records from them. They ask us for medical releases, and they go out and get all these records that they want for prior existing treatment, and then they send us a set. And then it's up to them to redact out bad things that are said about their client. Because there are a lot of times that a doctor will comment on Dr. Durrani. Dr. Durrani did a bad surgery again. This is the 3rd Dr. Durrani patient I've seen this week. And since that's not related to medical treatment, the judge lets them redact it out. They come in here and they raise this, and it's their own lawyers that didn't redact it out. And the PowerPoints have always been looked at 5 minutes before they get presented. And we fight all the time about, well, are you going to send it to it tonight? Are we going to do the 5-minute review? And then they want to say with Dr. Melman, another crazy red herring, well, they didn't have a report. Well, Judge Swikert and Judge Reese and trial counsel agreed years ago. We're not doing depositions of experts for discovery, and we're not exchanging reports. But they throw in, I don't have a single report from one of their experts, ever, in the last 6 years, 7 years. We don't do it. Now, suddenly, just last year, they wanted to start taking discovery depositions of our experts again. Maybe they've taken 1, 2. They don't do it. So these are all misstatements. I'm not saying they're intentional. They're not at the trials, but this is all clearly in the record. And it gets thrown up here to create the sense that I'm some voodoo doctor pulling all kinds of tricks out of my hat at the trial to prejudice Dr. Durrani while he's running his racehorses in Pakistan. It's just nuts when you know what's really going on here. And that's that Dr. Melman's been disclosed for almost 10 years, 8 years. It's all thoracic spine. It's a letter they gave us that they didn't redact, and they want to tell you all this is prejudicial error. Well, they can't create their own prejudicial error and then come in here and cry like little babies. They lost. And this case should be affirmed.
I guess the court will have to decide if it's okay with name calling. I choose not to do it. I think the court will also have to decide whether it's going to let someone argue things that are nowhere in their brief. You want to find common questions of law. In fact, they list dozens of facts in their briefs. I see no overlap between these two. This has been illuminating for a few reasons. We are now told that the only commonality you need to find is the question of really the fundamental question in any particular case. Was the standard of care violated, in this case due to an unnecessary surgery somewhere on the thoracic spine? You will not find precedent for something so general to be consolidated. Consolidation, you mentioned, Your Honor, the criminal case. Well, if a group of people rob a bank together, you put them together at trial. If different people rob different banks or different people rob the same banks unconnected, you don't put them together for trial.
So is the difference here one act of negligence, let's say, or criminality versus multiple acts? One can be consolidated and the other can't. Is that what you're arguing?
Well, no, I think our argument's much broader than
Okay.
that. I think we've
Is that
made a
one
whole
of
lot of
your
arguments. I think your concurrence captures several of them. I think the mandamus decision, while not going our way, captures a lot of them. I think Judge Krause's questions capture a lot of them. The other thing, I'll just emphasize this again. My colleague always says, well, we tried 6 of them in federal court. That's the Atwood case. That case has not gone to a court of appeals. That still sits in the trial court. It has not yet been reviewed by anyone. This Court of Appeals is the only Court of Appeals we know of that has blessed these kinds of cases. So when they say they've tried 6, doesn't really matter because no one said it's okay yet. The other really illuminating
The
thing.
district court did.
The district court did. Yes.
Okay. So the district court did the analysis?
The district court did an analysis, yes.
Okay.
We will.
You're
we
going to
will
say
disagree
the
with
district
this
court did it
analysis.
wrong, but the district court did an analysis to determine that the 6 cases should be tried
Sure.
together.
The district court, following a precedent that it was involved in when it was a lawyer. The Scioto case, the judge in Atwood is the lawyer in the Scioto case. So there is a commonality of the only 2 cases that we can rely on at all, and candidly, the Scioto case is the only one decided by a court of appeals. I find that interesting. I think it makes appellate review all the more important. A 6 plaintiff case, you haven't seen that yet. I hope you don't. It is eye-popping. The other thing that you heard emphasized is the timing. And my colleague said at the end, we can't create prejudice and then cry about it. Don't forget, this is why we put this in the briefs all the time. These cases start in Butler County. They lose 4 out of 5 on the plaintiff's side. Then they concoct a scheme to bring them to Hamilton County to try to merge them under Judge Ruhlman. It takes years for the Ohio Supreme Court to say that was unlawful, you can't do it. There then is an effort to take these to federal court because they are trying to make them a mass action. 500 plaintiffs, they wanted a 500 plaintiff trial with 1 jury. Who's creating the prejudice here? Who's creating the long timeline? Those were all decisions that plaintiff made when they weren't getting the results they wanted in Butler County. They don't refute that in their briefs. It is evident from the record. I think it is indisputably true that when you look at the delays and the prejudice that has occurred, they've tried to push to have as many people together at once because they lost 4 out of 5 individual trials. That's the record in this case. Judge Bach, to try to answer your question, in our view, the nunc pro tunc just comes too late. This estate has known about this case since it was filed. The estate filed the case. It chose voluntarily to close its to settle it with this case pending, and then decides to reopen it on the eve of trial or on the eve of a jury decision while it's with the jury, in order to rescue something they should have done years ago. And to Judge Krause's point, it all happens overnight in a different court, where you would have, I guess, potentially had to intervene on appeal, hope to win, and then file a notice of appeal in that court that the nunc pro tunc order was invalid.
You have 19 seconds left.
Are there any other questions? Thank you all for your time today.
All right, thank you both. Clearly, it's been a long history. I would suggest to both sides to, in the future, just try to keep it to the case itself.
I'm sorry, I couldn't hear you.
I said, clearly, it's been a long history. I would suggest to both sides to try to keep it to the case, future arguments. With that, we conclude the proceedings. We take the matter into submission, and we will be issuing a timely decision. Thank you.